I'm sending notice now to DPS so that every single officer in the state knows that you are not allowed to drive a vehicle that doesn't have an interlock. If you're caught driving a vehicle, it doesn't have an interlock, they will arrest you and put you in jail.
That's not just a warning. It's a full-on judicial MIC drop. The judge is essentially firing a statewide shot at law enforcement. Touch a car without an ignition interlock and you're headed straight to jail. Harsh? Maybe. But after a second DWI, the courts aren't leaving anything to chance.
Giving you a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. You will also be tested for illegal drugs as well. You test positive, you consume alcohol, into jail you will go. You cannot justify driving for any reason. If I find that you do, I will revoke your bond and put you in jail. I don't know what your immigration status is. Good morning, Ms. Dews. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay. Ready?
Yes, Your Honor. On March 18, 2025, at 5:21 p.m., an officer was dispatched to a theft at Walmart with a female in custody. Upon arrival, the officer took custody of the female identified by her Texas driver's license. The officer searched the defendant before passing custody over to another officer. That officer spoke to the loss prevention officer who stated he was following the defendant in the store and observed her concealing items in her purse and backpack. This was done in a blind spot of the cameras, so there were not videos. The defendant then continued shopping before checking out and paying for some items. The defendant did not pay for the items she had concealed in the bags and passed all points of sale before the loss prevention officer stopped her. The defendant admitted to stealing before turning the items back over. The total value of the items was $120.
Classic theft setup. Concealment in the camera's blind spot. But here's the key point. Admitting to it and returning the goods doesn't magically erase a crime. Shoplifting laws hinge on intent and action, not on whether you hand the items back after being caught.
Makes sense.
Thank you. Ms. Dews, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any Walmart for any reason whatsoever. If I find that you do, I will revoke your bond, put you in jail, and no more PR bonds for you. Do you understand? Yes, sir. Likewise, if I find that you pick up any new cases, your bond will be revoked. You will go into custody, man. Do you have the ability to hire a lawyer? Okay, I will have you fill out an application. Deputy Miranda is going to give you an application. I'm going to have you sign a receipt with Victoria. After that, we'll have you take a seat in the jury box while we get your bond conditions ready. Do not leave until you sign them. Okay? Please. Do you mind filing those? No going to any Walmart?
Yes, Your Honor.
Anywhere.
No Walmarts anywhere?
Anywhere.
Thank you, Your Honor.
Mr. Reyes, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Simply. Okay.
Officer was dispatched to a minor crash in Harris County, Texas, where the defendant had rear-ended the complaining witness. Upon contact, the officer found the defendant in the driver's seat, slipping in and out of consciousness. When the officer woke the defendant up, the defendant attempted to start his car and drive away, but at that point, officers had his keys. The officers did not notice any injuries on the defendant. When the defendant exited the car, he was unsteady, and officers observed an odor of alcoholic beverages, bloodshot eyes, and slurred speech. The defendant admitted to drinking at a bar earlier. Standardized foot sobriety tests were conducted, and the officers observed 6 out of 6 on the HGN, 8 out of 8 on the walk and turn, and 4 out of 4 on the one-leg stand. While en route to the Joint Processing Center, the defendant fell asleep in the officer's vehicle. At the Joint Processing Center, officer read the DIC and defendant consented. However, the defendant fell asleep again.
This is a moment everything unravels. Passed out at the wheel, a failed attempt to flee, and finally vomiting in custody, the trifecta of a DUI disaster. What began as a minor crash quickly spiraled into a full-blown medical and legal crisis, and with that blood warrant, the final nail in the coffin was sealed.
And vomiting. The defendant was transported to the hospital, and a blood warrant was signed and executed.
So no breath test was done.
No, Your Honor.
Mr. Can you run his license, please? See if there's a valid license.
Yes, Your Honor.
Mr. Reyes, I'm going to find that there's sufficient probable cause to go forward with your case. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not, I'm going to give you a portable device. You're not allowed to drive any vehicle from now on that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock on it, I'm going to put you in jail and I'm going to make your bond high. Do you understand?
I understand. It says ineligible.
You are not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive. Mr. Reyes, heed this warning. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car and drive. Do you understand?
I understand.
You cannot justify driving for any reason. I don't care if there's a burning building and you have to save 50 babies. Do you understand? Mm-hmm. I'm sending notice now to DPS so that every single officer in the state knows that you are not allowed to drive a vehicle that doesn't have an interlock. If you're caught driving a vehicle, it doesn't have an interlock, they will arrest you and put you in jail. I am now giving you a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. You will also be tested for illegal drugs as well. You test positive, you consume alcohol.
And here we are again with the ignition interlock lecture. But make no mistake, this judge is locking in airtight accountability. These devices aren't just breathalyzers, they're mobile evidence collectors. Miss a test or trigger positive result. And it's straight to jail. No day tours, no excuses.
Jail you will go. You have the ability to hire lawyers, sir.
I do.
We're going to give you time. I'm going to have you come up here, swear to us that you're not going to drive. I'll get you to Victoria. We'll have you sign a reset. You will get with police for your bond conditions, and after that, you're free to go.
These songs from private.
You're good.
Thank you.
Good morning, Mr. Sullivan.
Good morning.
Sir, you were charged with assault with a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On March 23rd, 2025, at approximately 15:39 hours, the law enforcement officer was dispatched to an address in Harris County, Texas. In reference to a disturbance. When the law enforcement officer arrived on scene, they made contact with a witness who stated that her husband, the defendant, had been arguing because her adult daughter does not like the defendant and asked the complaining witness to pick between having a relationship with her and her grandchildren or the defendant. The complaining witness stated she decided to sever a relationship with her daughter and informed the defendant that she would be moving back to Arizona. The complainant was stated this upset the defendant and he began arguing with her. She then expressed that she hated him and this made the defendant more upset and he told her to hit him if she hated him so much. The complainant was stated she hit Mr. Sullivan with a closed fist on the head and face area 3 times before losing balance, slipping and falling. This fall caused her to hit her face on their bedroom dresser. The complainant then said she got up and crawled into bed and she was laying on the furthest corner of the bed, closest to the wall, and covered her body with a blanket. The complainant witness said that approximately 10 minutes went by. Mr. Sullivan, the defendant, continued to argue with her. He crawled on bed, grabbed her, flipped her over, her back was on the mattress, and used his body weight and then on top of her while placing both hands on her upper arms to hold her down. The complainant said this caused her pain, and she was able to free one of her arms and use her hand to grab the defendant's genital area and making him let go of her completely. The defendant then used his right hand and punched the complaining witness on her mouth, causing pain and visible injury.
This case is a legal knot. She strikes him first, making him technically the initial victim, but it quickly spirals into a troubling escalation marked by physical dominance, restraint, and alleged injury. While the law often seeks to identify the primary aggressor, in a situation this tangled, that determination is anything but clear. What's your take?
When it was added, the fight then diminished, and the law enforcement officer observed visible injuries, including large pulpal bruises on both arms and injuries to the top and bottom inner lip.
Blaze, are you hearing this?
Yes, Your Honor.
Interesting. So she's the initial aggressor, though, correct?
Your Honor,
So it looks like he says, hey, hit me, antagonizing. She gets into it. She pops him, what, 3 times in the mouth, you say?
Yes, Your Honor.
No, don't say anything. Sorry.
So, Your Honor, only thing I would ask is, this is not on court's case. If we can just stand down, wait for the DVD prosecutor to be here. I don't know if he's spoken to the point yet, if he has anything more to add. I would just ask the court to withhold the finding until we can get the prosecutor here.
All right, Mr. Sullivan, just do me a favor. Will you just take a seat in the jury box? I'm going to get, I'm going to also appoint him a lawyer, if you don't mind. I'm going to appoint him someone as well so we can do just.
That's fully fine, Your Honor. Let me, and I'll email DVDs. Yeah.
Okay, all right.
Thank
Do me a
you.
favor, just take a seat for me real quick, all right?
All right, Judge, next is page 14. Yes, you can come on up.
Mr. Guest, you are charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. Your case is 180 days now. You have taken off multiple times on us. It is now time to figure out what we're going to do with your case. I'm going to appoint you a lawyer today and we will figure out what we do with your case. Do you understand? Take a seat for me in the jury box, please. You're Abner Guzman.
Guzman. Yes.
Mr. Guzman, you're charged with displaying a fictitious license plate. 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you. On March 24th, 2025, at around 11:20 a.m., officers were dispatched to a DMV call at 2520 Airline Drive in Harris County, Texas. Upon arrival, officers observed the defendants
He's been driving around with a fake temporary tag for 4 years, obtained through WhatsApp, and that's far more than just a traffic violation. It's outright fraud. Instead of shielding him from legal consequences, using fake tags only heightens his liability and deepens his legal exposure.
vehicle parked in the west side parking lot near the fence of the
Houston Farmers Market.
With the front passenger window broken.
Con la ventanilla del pasajero del frente quebrada.
Officers conducted a vehicle check
Registro vehículo
on the temp license
en la
plate
licencia de manejar temporal.
and returned it without
La
match
placa. Y regresó, lo tenía ahí.
the defendant's
El
vehicle.
vehículo del acusado.
At 12 p.m.,
A las